How's everybody doing this evening? All right, try to give you a little information tonight, but before we start, the Florida Bar has certain rules and regulations regarding what information I can talk about with people at events like this. Legal information is not the same as legal advice, which is the application of law to an individual's specific circumstances. The general information presented during this public service event is not intended to be construed as legal advice, nor should it be used as such by any person attending this event. Any legal question you may have regarding the content of this presentation or your legal rights should be addressed to a duly licensed Florida attorney. We're going to try to answer questions for everybody. I'd like you to try to keep your questions as broad and general as possible. The rules do not allow me to basically sit down with a client and start picking apart their case in an event like this, so I hope you do understand. Okay. About 2.5 million homes have been repossessed since 2005. And there's another 6.5 million mortgages are in foreclosure or may be soon. This is from the Bloomberg report of October of last year. Nearly a quarter of all mortgaged homes are underwater. That is where the outstanding loan balance exceeds market value. From the National Legal and Policy Center of October of last year. Are you one of the millions of people facing foreclosure due to personal hardship, job loss, illness, divorce, excessive debt? Any of these things could have prevented you from making your mortgage payments. Well, you're not alone. 1 in 10 mortgages in 100 largest metropolitan areas are seriously delinquent. This is from the Center for Housing Policy, March of last year. In the state of Florida, we are now number 2 in the country in foreclosures, trailing only Nevada. 50,685 filings in May. In May alone, up 5% from April. If anybody tells you it's getting better, it's just not happening right now. It's getting worse. What is a foreclosure? Foreclosure is a legal action to force the sale of a home caused by failure to make payments. If you're a homeowner who is currently facing foreclosure, or if you've already been served foreclosure papers, important legal rights are at stake. And if you don't act quickly, you can lose those rights. I'm going to discuss the phases of foreclosure here in the state of Florida. First, you're 30 days late. You receive a letter from the lender advising that they have not received the payment. 60 days late, generally, second letter from the lender advising that they haven't received it and you need to remit a payment, otherwise you will promptly face a foreclosure action. 90 days late. This is the notice of default from the lender advising that they have not received payment and the file has been forwarded to their legal team to initiate foreclosure. This is basically when the bank says, that's it. We're giving it to the attorneys and we're letting them handle it. That puts you on notice when you are getting a notice of default that a lawsuit is coming. Generally speaking, 4 to 8 months, a foreclosure is begun when the lender makes public notice that they intend to initiate a legal proceeding. The filing is referred to as a lis pendens. This is fancy legal term for pending legal action. You will get served in person. Somebody will knock at your door and they will serve you paperwork, which will include a lis pendens. A lis pendens is filed by the lender. You have 20 calendar days. It will state this on the complaint. You have 20 calendar days to respond to the complaint. You either respond or you don't. If you do respond to the complaint, then the lender must prove their case in court. They do not automatically get a default judgment against you, and then you are entitled to question whether or not the lender has the right to foreclose on your home. If you do not respond, then the lender is awarded a default judgment. No fight, no argument, default judgment. They'll publish notice of a sale 2 weeks prior to the sale date. Auction will occur. Occupants are evicted. Now, if your house sells for less than what you owe, then the lender could be awarded a deficiency judgment from the court. If the lender is awarded a deficiency judgment, the lender may seek to garnish wages. A deficiency judgment is the difference in the value of what they sell the home for versus how much you owe on the loan. If they take your home and you owe $200,000 on the loan and they sell the home for $150,000, they can come after you for the other $50,000. It's what's known as a deficiency judgment. It happens to people who choose to walk away from the situation or bury their head in the sand and act like it's not happening. Then you can guarantee a deficiency judgment is going to be tacked on. Now, you have options when you're facing foreclosure. Of course, you could repay or reinstate the loan. If anybody could do that, I don't think you'd be here tonight. You could look for a forbearance program, and I'll get into these a little bit more in detail. You could try to sell the property. You could look for a deed in lieu of foreclosure, perhaps a short sale, bankruptcy. Maybe you're seeking federal foreclosure help, loan modifications, or you can fight your foreclosure. Of course, if you could repay your loan, you wouldn't be coming here tonight to try to figure out what to do. You can reinstate a loan at any time by coming current on the loan, by paying up at any time, and the proceedings will end. The worst thing that I ever see people do, though, is make partial payments to their lender. If you make partial payments to the lender, you're throwing your money away. If you do not make full payment and make partial payment, they will take that payment and they will put it to penalties, fees, and interest, and not a dollar of it will go to the reduction of the principal balance. It could offer you a forbearance program. Forbearance is a temporary agreement with the lender that allows delayed payments for a limited period of time. There are potential challenges, of course, with the forbearance program. You still must be able to prove that you will be able to pay on an ongoing time frame. A routine payment schedule will also restart after the temporary forbearance period is over, and skip payments are added to a loan balance. Generally, what I see in forbearance programs is people putting off their problems for 6 months, maybe 9 months at the most, and then having to deal with it at that time. It really doesn't do anything. It doesn't get you out of the woods. It just puts off the inevitable. You could try to sell the property on the open market. Challenges with that as well. The current Florida real estate market conditions are extremely poor for people looking to sell. There is a very large inventory of homes for sale. It is a buyer's market. Buyer financing is also limited. And of course, most Florida homes, well, they're upside down in equity. So again, you have to worry about deficiency judgments. Now, you could try to obtain what's called the deed in lieu of foreclosure. This is when the bank has you sign your deed over to them rather than go through the entire foreclosure process. You just have to be very careful when you're doing this as well, that there's potential challenges associated with it. You want to make sure that if you're going to offer a deed in lieu, that you've negotiated away the potential for a deficiency judgment. You have to watch out because most of the time property value is insufficient when it comes to selling the home or offering it back what the value of the home is worth versus the loan. Now, you're going to have some damage to your credit associated with this as well, and you could have potential tax consequences. So you want to make sure you speak to your tax preparers about how this may affect you. Now, you could try to conduct a short sale. This is when the lender agrees to accept less than what is owed on the property to satisfy the lien. Now, there are potential challenges as well with the short sale. Again, lack of qualified buyers. The biggest problem I see with short sales, lenders may be unresponsive. I get people all the time who tell me I had someone who was ready to buy the home. For 30 days, I could not get somebody from Bank of America on the phone that could make the decision that would allow me to sell. What happens? Buyer ain't hanging around all day. They're saying, can you close this deal or not? I'm walking. I'm going to go find something else. Of course, you still have the potential for credit damage. Deficiency judgments are possible unless they are negotiated. Again, tax consequences. one of the more unique aspects of short sales, title companies may not insure the sale. Why is that? Now, why does a title company, what do? They insure during a sale that the title that is being passed is free and clear. If they are refusing to insure short sales, that is because they don't believe, or they believe there's a chance that the person who's selling that house can't prove that they actually own it. They don't want to come out of pocket. Title companies lose huge money if they insure a title that has a spot on it. Usually, from what I've seen, the only person that benefits in a short sale is the person who's buying it. Now, bankruptcy is always an option. It's what we call the nuclear option in foreclosure defense. You could go through a Chapter 13 reorganization or Chapter 7 liquidation. To me, again, it is the path of